It was a moment of weakness. She was going through a divorce at that time with her husband. It was more of an attention-seeking text message in the heat of the moment.
Grant Snyder versus Bethany Lincoln.
This matter is before the court on the plaintiff's motion for order suspending defendant's parenting time, motion for change in custody and support. Mr. Toth.
The heart of this motion has to do with the not only the well-being of 11-year-old Ellie, or soon to be 11-year-old Ellie, but her safety. Your Honor, I think that taking the 10,000-foot view, I think the facts that have been alleged and even the admissions that have been included in the answer certainly indicate that we have identified facts that would authorize moving forward to a custody hearing. We have certainly identified good cause as well as a material change of circumstance, if the facts are proven true, that would warrant a hearing in this matter. So that's the broad view. And as we take a closer look at things, Your Honor, and it has to do with the suspension of parenting time, with all due respect, I would say that the verified answer in this case really raises as many questions as it answers. I think it's absolutely been acknowledged by the defendant in this case that there are mental health issues that are ongoing, and they're really extraordinary. I would point to the admission that was made on page 3 of the answer, paragraph 7C, where there's a candid admit that defendant threatened suicide on September 7, 2023. Defendant. Those two sentences, Your Honor, are absolutely contradictory. You don't, if you've threatened, then to suggest, I'm not sure that that's logical, makes sense, and it certainly warrants gathering more facts and investigation in order to determine whether or not that you can both threaten suicide and in the next breath say, I'm not suicidal. In the defendant's petition to terminate the PPO, which has been recently filed, and I would say, Your Honor, that PPO, I think, is in effect, and I would suggest the fact that the defendant's apparently now residing with her husband violates that PPO. The defendant's statement is, I have been experiencing some overwhelming mental health challenges that have led me to make irrational decisions. And she goes on to say, I have started my journey by seeking help. So again, an admission of overwhelming mental health challenges and making irrational decisions. Your Honor, with all due respect, it would be my position until such time as we can have a hearing, that we can have a psychological evaluation conducted, that we can gather some evidence through discovery. I think the allegations that we've made and even some of the answers that have been acknowledged, I think that there is clearly a safety risk here. This isn't, again, you can't be threatened suicide and say I'm not suicidal. That's just not fair to conclude that there's not an issue because I say there isn't one. So, Your Honor, I would respectfully suggest that the suspension of the parenting time continue until such time as we can do some at least initial discovery and have the matter scheduled for an evidentiary hearing, not only on parenting time, but also on the much broader issue of a change of custody, as well as an alteration of the long-term parenting time schedule. Thank you.
Thank you. Ms. Samuels.
Thank you, Your Honor. Obviously, we're here today, and I think the main thing that I want to address is the fact that obviously there has been a suspension of parenting time. A hearing was supposed to be scheduled. It wasn't. I ended up scheduling it with the court to get mom in front of the court to address the suspension in parenting time. You know, she's already missed 2 weeks of parenting time with the child. This child has been going back and forth, week on, week off, between her two parents since she was 2 years old when the parties separated. She's now about to turn 11, I believe, on Friday. So this is a major impact on the minor child as well, which I think needs to be in the forefront of everyone's minds. I think that there's some steps that we could take to alleviate some of the concerns here that dad has. One, mom has already done a psychological evaluation. She did so in her own accord. You know, I indicated I would be happy to disclose that to plaintiff's counsel. However, I would ask this court for a protective order just so that, you know, her psychological evaluation isn't just given to the parties or anybody else. But she's happy to disclose that her diagnoses were not super severe. She was diagnosed with generalized anxiety, depression, and PTSD from some past traumas. It was recommended that she start therapy and see a psychiatrist to discuss exploration of medication. Both of these things she has done. She has started going to therapy once a week. She started therapy on the 9th of this month. She also started seeing a psychiatrist, and she has since started taking an antidepressant. All of these things happened after that. The therapy and the medication started happening after the September 7th date where she threatened suicide. She is not suicidal. The threat of suicide happened. It was a moment of weakness. She was going through a divorce at that time with her husband. It was more of an attention-seeking text message in the heat of the moment. And since, as I indicated, she has taken steps to make sure her mental health is under control. You know, on top of that, the PPO, there is, as Mr. Talk indicated, there is a motion to terminate the PPO. It's scheduled for this Wednesday. So that should be resolved on Wednesday, one way or the other. Mr. Snyder actually did a welfare check of the child when the child was at mom's home with the husband present when the PPO was in place. The police decided that the minor child was not in danger, did not take the minor child from the home, did not arrest Ms. Christensen's husband, indicating that he was in violation of the PPO because the officer understood that there was a motion to terminate the same and that mom was not in danger. All of that has also been alleged in the motion. So, you know, the police has also indicated that the minor child wasn't in danger when they arrived at that home. You know, there's a lot of allegations that there's physical abuse happening in this home. There's not. Neither party's ever been arrested. There's no domestic violence history. There's no criminal history at all. Mom is not utilizing drugs. There's no drug use. She takes prescription Adderall, and she takes it as prescribed. Other than that, she does not use drugs in any way, shape, or form, and she's happy to take a drug test. If this court wants to order a drug test for her, she will take one at any time.
Ms. Samuels, Mr. Toth had alleged that at the time she was hospitalized, she did have methamphetamine and ecstasy in her system. Are you saying that's incorrect?
The methamphetamines in her system, methamphetamines and amphetamines are tested the same. I have the drug test. It says methamphetamine / amphetamines. That's the Adderall in her system. The ecstasy in her system, as I'm sure this court saw in my response, she was drugged. A date rape drug was put in her drink. And that is the ecstasy that was found in her system.
Okay, anything else?
I don't believe that this child is in danger in mom's care. I think that the well-being of the child not seeing her mom at all, especially when I have to imagine an evidentiary hearing is probably not going to be scheduled in a week or two. So to keep this child from her mother when officers have been at the home and don't believe that there's a danger and mom has taken steps to make sure her mental health is in check, I don't believe that keeping the suspension of parenting time is appropriate.
Okay, thank you. Well, I'll tell you, just so you know, I don't rely upon, again, hearsay or any inferences from that any police officer might say when they're on the scene for a limited period of time. So that is not persuasive in any way. What the court will note in this particular matter is that most recently, there was a recent case release, Beretta versus Sitkoff. It was released on October 12, 2023, released for publication, but we don't have any citation yet. And that case happens to go through and set forth the law and the standard for suspension of parenting time. And it states that parenting time can be suspended where, again, the evidence shows that it would have an impact and endanger the child's physical, mental, or emotional health. In this particular matter, I think based upon the allegations that are not disputed, that she did in fact threaten suicide, that there is sufficient evidence as to the answers as well, that she has some substantial emotional and mental health issues. So the court does believe that pursuant to the Beretta case, that there is a basis to, again, establish that it would impact and affect the child's physical, mental, or emotional health. So the court is going to continue the suspension of parenting time with some provisions. The court does note that as well, there's proper cause and change in circumstances to meet the Vadvarka threshold to proceed in this matter for change in custody. So the court will have an order of hearing. We'll contact both attorneys' offices and see when we're able to schedule that. But it does appear that based upon what's been said, that you're going to need some period of discovery. The court would order that the defendant would release the psychological evaluation as well as any other reports that come up in this matter to Mr. Toth, and that the court will also order that that be through a protective order, so there'd be no dissemination to the parties or any other individuals other than Mr. Toth himself or anybody working in his office on this particular matter. The court would, in the interim, award to the defendant some supervised parenting time. If a period of time of 3 hours per week on Saturday from noon to 3 o'clock, the court would order that the plaintiff would provide 3 names of supervisors within 7 days of today's date. And the defendant then has 7 days to choose which of those individuals would supervise the parenting time. And after her designation of that, then the matter would proceed on that following Saturday. So I'm assuming it won't be this Saturday, but the following Saturday appears that that would work for starting the parenting time, which would be again the week of November. Well, it'll be November 4th then, so we'd have it start at that time. With that, I'll ask Mr. Toth that you would prepare the order in this particular matter and submit under 7-day notice of entry. And looks like that concludes this matter at 9:49 a.m. Anything else, Mr. Toth?
No, Your Honor.
Okay. Ms. Samuel?
No, Your Honor.
Okay, thank you. Have a
Thank
good
you.
day.
Thank
Have
you,
a-
Your Honor.